Because sometimes what you need is not a change of personnel, you need a change of structure.
Parental Rights Amendment.
Right, that's in Congress now, yeah.
Which was authored by Michael Farris.
As I understand, ultimately authored by Michael Farris. So it has 4 provisions that are of interest here. The first one just says that the liberty of parents to direct the upbringing, education, care of the children is a fundamental right. Well, we know that already. It's part of the life, liberty, pursuit of happiness Declaration. Then it goes on and specifies that that particular right includes the right to choose public, private, religious, or home schools, and to make reasonable choices within public schools for one's child. Now that's interesting, to make reasonable choices, because the suggestion then becomes if someone thinks that the choice is not reasonable, then this right doesn't exist to that extent.
And who determines
and
what?
And the question is, yes, and who is going to determine that? Well, we would have to assume the first place would be the parent, but the parent could be overruled by some state agency. Right? We have those agencies already in place, the Child Protective Services agencies, the schools, of course, public schools. Then he goes on, Section 3, neither the United States nor any state shall infringe these rights. Would have been nice if it stopped there. But it goes on to say, without demonstrating that its governmental interest as applied to the person is of the highest order and not otherwise served. Well, that puts these rights entirely at the control of whom?
The government.
Of the government. In some way, legislatures could pass statutes dealing with these questions. Administrative agencies, public schools, child protective services, ultimately the courts. Now, what interests me about this particular provision is that it constitutionalizes the Supreme Court's so-called compelling state interest theory. That if the government has a compelling interest and it exercises its authority in the least restricted way, it can violate essentially any right that an individual claims. Well, that has always been a judicial doctrine, a false judicial doctrine, and one that could have been overturned at any point in time by the legislature. Now it's been made a constitutional doctrine. And what's interesting about it is, of course, it's totally non-scientific. The governmental interest is of the highest order. Measured how?
By whom?
Well, by whom, of course, but measured how? Assuming that we can find someone to do it. How is he going to measure this, right? So this person's decision, or that person's decision, the legislature or the court, or 2 justices on the Supreme Court, it's non-verifiable and it's non-falsifiable because there's no standard. It's in the eye of the beholder, like beauty or ugliness, whichever. Right? And then it says, well, the governmental interest cannot be otherwise served. What's the criterion for determining that? Otherwise served to what degree? At what expense? And on we go. This is a very dangerous provision because it's open-ended and it constitutionalizes a false judicial doctrine. And then the final provision, that is Section 5, no treaty may be adopted which shall, nor shall any source of international law be employed to supersede, modify, interpret, or imply to the rights guaranteed by this article. Well, we know that already. Constitutional provision, no treaty can interfere with that, override and modify and so forth and so on. The great danger of this is it's accepting the contrary doctrine. It's assuming that treaties could override a constitutional provision, and it requires a specification of the constitutional provision to exclude that power under a treaty. And what this would do if it were enacted, people would look at this and say, well, no treaty can apply to these parental rights
Yes.
because we have this section that says no, but that must mean that the treaties could otherwise apply to all of those other rights for which there is no exclusion built into the Constitution. And that, of course, would overturn the doctrine that's been constitutional law in this country since middle 1800s, early 1800s, that no foreign law can override United States law, even if the President and the Senate approve, because the President and the Senate are not amendatory bodies. They cannot amend the Constitution with the agreement of some foreign government. So this thing may not have been intended as such, but it's a terrific Trojan horse.
It flips the supremacy clause on its head.
Yeah, exactly, the opposite. Now the foreigners can come in with the President and the Senate. You get your 2/3 of the Senate and the President and some foreign government. They come up with a treaty, and now the treaty can override, well, in theory, not this, because there's an exclusion, but essentially anything else. In the
Perhaps Sharia law?
Yeah. Well, globalism in general, right? The foreign government, UN, right? It's not one foreign government, let's look at a consortium of foreign governments. The UN, the treaty organizations, NATO-type organizations that are set up, International Monetary Fund, you run down a list of these things, right? And according to the interpretation that I would give to this, fair interpretation, in any area where there wasn't an exclusion like this built into the Constitution, those foreign bodies in collusion with the President and 2/3 of the Senate could start changing American constitutional law. Which, by the way, overrides what besides the Constitution? The Declaration of Independence, the separate and equal station to which the people of the United States are entitled under the laws of nature and nature's God, right? The interpretation of this thing, as I imagine it would be interpreted, would essentially say, well, that's an aspect of the Declaration of Independence is no longer applicable. These foreigners can come in and have a controlling influence.
And Coach, there's some people that advocate that now. Some even
They've been advocating for a long time.
Right.
I mean, there was like, what's it, Bricker? There was a thing was called the Bricker Amendment under Eisenhower, where it was proposed, this Section 5 was proposed as the amendment, that no treaty could override the Constitution because they were so worried about the UN, of course, at the time. And that there was a school of thought being bandied around that yes, the Constitution could be overridden by a treaty and therefore could be overridden by the UN. Because the UN, we were signatories to the United States, signatories to the UN through treaties, and therefore whatever the UN did that we didn't veto in the Security Council would somehow come back and be controlling in this country, notwithstanding what the Constitution said. So Bricker came in and had, I think it was Bricker came in with an amendment similar to this. And I always thought that was a very dangerous thing because he was accepting the proposition. If that had ever been put out and rejected, that would have accepted the proposition in principle that treaties could override the Constitution, and then we would be much further down the road to globalism than we are now. So what do you want to say about this guy? I don't know. Children, dealing with amateurs and children. Now, I do not attribute to him necessarily malign motives. I don't think he's a stooge of Soros. He could be, who knows? But I don't attribute that to him. This is just like opportunism of the worst
just
kind.
on its face, so it's bad. Regardless of the motive, that's it's bad.
Yeah, it's
And
bad.
would you agree, I debated their staff counsel, Robert Kelly, in Yorktown a couple weeks ago, and actually on the Ides of March. I guess it's been about a month ago. And when he talks about limiting, that their application is limiting, and yet it includes limiting the power and jurisdiction of the federal government. And our argument is that not only does the Convention of States application cover the whole Constitution, because what was the Constitution if not to establish the power and set the limits on the jurisdiction and that power of the federal government? And when this here creates a new power. Now, what they've been arguing is that it's a limited convention, that limit means reduce. And I argue with Counselor Kelly that limit doesn't just mean, limit could mean expand. It just means you're putting limits on them. And with this Parental Rights Amendment, which is authored by the head of the Convention of States Project, Michael Farris, that this is not only expanding federal power and state power, because it references both federal and state governments, but it's creating a new power.
Absolutely.
So it's not a reduction. They're not reining in the federal government.
Let's see what they say about it. What their model application says, the purpose is to impose fiscal restraints on the federal government, to limit the power and jurisdiction of the federal government, and limit the terms of office for federal officials and members of Congress. It's verbatim, right? So this is what they're advocating. So let's look at this. Let's look at what this means. How many articles do we have in the Constitution? Does anybody know? 8. No. The Lord gave us one for every day of the week.
7.
Okay. So the first one, they're talking about fiscal restraints. So really, they're talking about this. The last one, they're talking about term limits for the office and for officials, for the members of Congress. So again, they're talking about this. All right, well, let's look at this. Limit the power and jurisdiction of the federal government. Number one, it sets up the authority and jurisdiction of Congress, right? So that's got to go. And number two sets up the jurisdiction and authority of the president, right? So that's up for amendment. Number three sets up the judiciary, right? There we go. Now, this relates to the federal government, among other things, the federal government protecting our Republican status and from invasion. That's got to go. But this is amending the Constitution. They're going to change that because they want to give the states a shortcut to do that. So that's got to go. Oh my, right? And here we go. That's got to go. So this, which is moot because this is the ratification, the original ratification that they use for our Constitution, rather than using Articles of Confederation, which they were supposed to do. What does that tell you?
Now, one thing Mr. Lewis has pointed out is our application is fairly broad. It specifies 3 topics that the convention can consider. It can consider fiscal restraints on the federal government. It can consider items which limit the power and jurisdiction of the federal government. And it can consider term limits for federal officials. So that would be Congress, that would be members of the Supreme Court. And Mr. Lewis's argument against this is that it opens up all the articles. And that's true. Well, not all the articles, as he pointed out, the 7th. Article 7 is kind of out of the picture here. Article 6 not going to really be touching that. But it does open up Article 1, dealing with Congress. Because guess what? Congress is part of the problem. It opens up Article 2. Why? Because the president is part of the problem. It opens up Article 3. Why? Because the Supreme Court is part of the problem. It allows us Article 5 to be considered so that the states don't have to go through this convoluted process in the future. So that if 3/4 of the states agree in advance, they could propose amendments to the Constitution. It opens up these articles because the problem is not in an isolated single branch of the federal government. It's the president, it's the Supreme Court, and it's Congress. And if we limited ourselves to just touching one of those, we're not going to fix the problem. We're just going to shift the problem from Congress to now the president's just going to pass more executive orders doing whatever he wants. We're going to have more lawlessness. No, we need to address the problem as a whole. That's why our application is worded the way it is. That's why it's so broad. But I'll point out, it does have meaningful limits. Mr. Lewis said it doesn't have meaningful limits. It does. It's limited to limiting the government. And yes, I used the word limit there twice. It's limited to limiting the government.
It was like the Tugwell poster from 1934. It's insanity, pure insanity.
Well, it's an example of people not thinking through the long-term consequences of what they're doing and what somebody else will make of this. I mean, apparently their whole theory is, well, we had these constitutional provisions that were clear at the time, and people have perverted them seriatim, with one step at a time, and now we're way the heck over here. Commerce Clause is an example.
Mm-hmm.
Simple answer. Strike down some of these Supreme Court decisions. Pass a statute, these things don't apply anymore. We're not going to apply them. If they ever do this again, they'll be impeached. End of discussion. Constitution doesn't apply to. affecting, right, or whatever, statute, boom. And it will be a high crime and misdemeanor if they decide such, boom, out they go. Statute, we don't need an amendment to do that.